topic of this presentation is less burdens, more laughs. That was our goal this year, after last year. I hope you're excited. I'm excited. So let me walk through what we're going to talk about. I'm going to talk about these topics today. So we'll go through what a preliminary injunction is, because that's foreign from last year. We'll talk about free speech rights, which are fantastic. We'll talk about parody, which is funny. We'll talk about defamation, which is great, and then we'll have questions. So to start with preliminary injunctions. A preliminary injunction is a form of relief. It's a remedy. And so an injunction is when a court says a party is not allowed to do something, they have to stop doing something, or they have to do something. It requires a party to change how they act. It's not about money. It's a remedy. And what that means is if you have a claim, okay, so in this case the claim is defamation, you can ask for money damages, that's a remedy, or you can ask for an injunction, that's a remedy. So that's the way the defamation claim works with the injunction. The claim is defamation. The remedy that your students will be seeking, or the plaintiff will be seeking, is a preliminary injunction right now. And preliminary injunctions are about equity, and that's fairness. So when we talk about equality, that's everybody gets the same thing. Equity means that the people who need more help get more help, okay? So the purpose of equity, there are these maxims of equity that complete the purpose. So we say equity considers done what ought be done. So we're not going to get hung up on the small stuff. If it's a form over substance argument, like you initialed this line instead of a full signature, we don't care about that because it's about fairness. There is a saying that says equity won't suffer a wrong without a remedy. So in this case, Denver Saidi says, I've been wronged, okay? And so court in equity kind of fill in the blanks of how to help me. There's really not, there's no statute that says, why yes, a court can take down a video from the internet, but that's what Denver Saidi's asking for in equity, and so that's what the equitable court would do. There's also a saying that says one who seeks equity must do equity. So if I'm a really bad actor and I'm lying to everybody and I'm defrauding everybody, and then I go to the court and I say, please do something that's really fair and helpful to me, the court will say, well, you're not a very fair person, and so I'm not going to help you very much. And those are the equitable maxims. So how does a preliminary injunction do this? We often say that a preliminary injunction maintains the status quo. And what that means is it will set the status quo while the case is pending and keep it there so no further harm happens. We say that it prevents a party from suffering irreparable harm, or it'll cease irreparable harm. So it's not necessary in every equity case or every preliminary injunction case for the plaintiff to have actually suffered irreparable harm. You can file for a preliminary injunction before you suffer harm. It just happens that in this case, the video is already on the internet. But it is true that you can attempt to stop it being posted if he would have caught it ahead of time. And finally, what the court does when confronted with a preliminary injunction is they balance equities. And what that means is, and we'll talk about it later, is you look at the plaintiff and you look at the defense and say, where is the balance of equity in this case? Does equity favor helping the plaintiff, or does equity favor helping the defense? And the court will balance those equities to try to do what's right. At the end of the day, in this posture, when you're this early in a case, because this happens like immediately in a case, the court is trying to figure out, how do I stop the bleed so we can litigate and research and figure out what happened and then come to final judgment later. So we're doing it on a limited record very quickly to just kind of stop everything, cease the harm, so then we can fully investigate the facts and come to a final decision. That's the purpose, and that's how injunctions get to equity's purpose. The video did a great job at explaining what the 4 factors to consider in acquiring injunctive relief are. These are the factors that the plaintiff should be addressing in their case in chief, that the movement, in this case the plaintiff, has a substantial likelihood of success on the merits, that the movement has or will suffer irreparable harm, that the balance of harms, that's kind of like the balance of equities, that the balance of harms weighs in favor of injunctive relief, and that the injunction is not adverse to public interest. The substantial likelihood of success on the merits is exactly what it sounds like and exactly what the video said. At trial, who's going to win? Right now, who do we think is going to win? If the plaintiff has a really strong likelihood of success on the merits, then the judge will say, yeah, that factor favors the plaintiff. The movement will suffer irreparable harm. Irreparable harm is not money damages, okay? Irreparable harm is stuff that cannot be cured by money. In this case, it's Saidi's reputation as a political official or someone running for political office. These votes are going to come in, okay? You can't pay somebody if their votes suffer because of what the defendant did. And that's what the irreparable harm would be. Weighing the balance of harms, we'll talk about this a lot later, but obviously you've got a free speech right, you've got a person who has a right not to be defamed, and so these are kind of at odds with each other. And that it's not adverse to public interest. I mean, think about the importance of elections. And so the public interest in this case, I think, tends that way. But that is something that we need to consider, that the court will consider when evaluating a preliminary injunction. I will say that some courts have said that the first factor is the most important. Some courts have said the second factor is most important. If I'm being honest with you, I don't know that in your packet it says one is or is not. I am here to tell you, you're going to love this. Call back to last year. This is a non-dispositive test. These factors go into the mix. There's a black box consideration with the court, and then out spits whether yes, no, injunctive relief, okay? What that means is there are cases that I have where I say, my public interest argument's really weak. I'm not going to focus on that. My case is really strong. I'm going to focus on my likelihood of success on the merits. I'm going to do the lawyer thing and try to make the best public interest case I can, but at the end of the day, I'm going to rest on the likelihood of success on the merits, okay? So it's not that you have to prove every single one of these if you're the plaintiff. It's not that you have to rebut every single one of these if you're the defense. These are non-dispositive factors that the court considers when evaluating whether it should grant or deny injunctive relief. The burden of proof, though, is by clear and convincing evidence. And so how I would say that is that the court must find by clear and convincing evidence that an injunction is appropriate by balancing these four factors, okay? So the ultimate finding of whether the injunction is appropriate, the plaintiff has to prove the appropriateness by clear and convincing evidence. To come to that conclusion, consider these four factors, okay? It is simpler, although I had to bring back the non-dispositive factors from last year. I know you all missed it very much. This is the section about freedom of speech. This is the portion of the First Amendment we're working with. Congress shall make no law abridging the freedom of speech. That means the government can't tell you what to say, compelled speech. I love the compelled speech doctrine, if I'm being very nerdy and honest with you. But we're also talking about what the government can't tell you not to say. So the reason that the government can't say, hey, you shut up, is because dissenters in society are important people. Especially in politics. We have a minority party all the time in politics. We have various minority parties in our political system, and they're very important to our political system. Importantly for this case, though, the judiciary is the government. And so when a judge says, hey, don't say that, you can't say that, they're impinging your free speech rights. And so that implicates the First Amendment, and that's why this case gets kind of hairy, but that's why this case is really fun. There's a couple of different restrictions on speech. There are two main categories, content-based restrictions and content-neutral restrictions. Content-based restrictions are worse than content-neutral restrictions. A content-based restriction means the state, the government, is stopping you from talking about something specific. You would have to look at what the person said to figure out whether they violated a content-based restriction. My favorite example is the state of Buckeye says, don't talk about Fight Club. All right, that's a content-based restriction. I am constitutionally allowed to talk about Fight Club. Maybe Fight Club wouldn't be happy with it, but I'm allowed to talk about it as far as the government's concerned. If you're in content-based restriction land, that's a very difficult test to overcome for the government. It's strict scrutiny. It must be, the law must be narrowly tailored to protect a compelling government interest. So compelling, narrowly, those are really strong words. You know, the plaintiffs love those in these free speech cases. On the other hand, a content-neutral restriction is a restriction that relates to speech absolutely, but it does not matter what the speaker said. in order to determine if the person violated the law, you don't have to ask what they said. My example is, hey, the city of Harmony says you can't play real loud music after 11 o'clock at night. Okay. Or you can't be real loud after 11 o'clock at night is even more content neutral. Okay. It doesn't matter what you say, you just can't be real loud because that's a city ordinance violation. Those are all over the place. In a content neutral restriction, it's the rational basis test. So the restriction must have a reasonable or rational relation to a legitimate government interest. And that is like, okay, Congress, do you have any reason why you're acting? Oh, you do? Cool. Is it at all related? It is? Great. And then it's gone. If you are in rational basis land, you're going to lose because unless Congress is royally screwing up their job, they're probably legislating at least on a rational basis standard. I mentioned this, but I'll come back. A content-based restriction gets closer constitutional scrutiny because that is worse. That is what like the founding fathers were really afraid of, the government telling you you're not allowed to say a certain thing. And that squashes dissenters and it chills speech. So that is why it's worse than a content neutral restriction. Okay, that is all I have on free speech. But now I want to talk to you about defamation. I love Judge Judy and I thought she should make a cameo. Defamation, let's start from this premise. The First Amendment only protects true speech. So if the government can say, don't lie to people, that's okay. There can be laws about that because lies are not protected by the First Amendment. Even better, if a lie causes harm to your reputation, that's defamation, okay? We call it a dignitary tort because if you are defamed, it's not like you can't walk or you have a bodily injury or something like that, but you still feel harm. And if you feel harm in a way where, let's say you get fired from your job, maybe you have money damages, okay? But it's harm to your reputation, your dignity. And so we call it a dignitary tort. These are the elements of defamation. There are 5 of them. It's a false statement, which is what it sounds like, a false statement. Maybe I should have added of fact, okay? It can't be my opinion about somebody because they'll say, that's not true. And I'll say, yeah, that's what I think. And then that's not defamation. So it's got to be a false statement of fact published by the defendant. And published in this case doesn't mean like a newspaper. It just means a third party saw it or heard it. So published by the defendant. The defendant is at fault, and I want to put a pin in that and come back to what at fault means later in a minute. Plaintiff suffered harm. That's a requirement in every case, or almost every case. And 5, the statement was not privileged. And I want to flag privileged for you because this could come up in some cases that your students read in the packet. Privilege does not mean like the attorney-client privilege or doctor-patient privilege. A privilege is just when you're allowed to say something. And so there is a concept of a privilege existing if your prior employer gets a phone call from a new employer you're applying for and says, hey, what did you think of Ben? Was he a good employee? If they say, no, oh, no, I think Ben's a horrible employee. In fact, here's this one story about this one time he royally screwed something up and you shouldn't hire him. Okay, if that story is false, it might be privileged nonetheless in Ohio. We have a privilege for employers hiring and sharing information about employees. It's a gray area. I didn't give you a perfect example, black and white of it, but that's like a privilege in this context. I'm raising this because this is not privileged, okay? You don't have a privilege issue in this case, but this is not the attorney-client privilege either. I don't want you to read this and all of a sudden be thinking, oh God, do we have to think about privileges and all that kind of stuff. The privilege word in this case means something different than maybe you're used to. So these are the elements of defamation. There are 2 kinds of defamation. There's defamation per se and defamation per quote. Defamation per quote usually requires that the plaintiff pleads or proves special damages. And by special, I mean itemized damages. So this is like when I didn't get hired because someone defamed me legitimately. And then I would say, okay, well, here's my offer letter that says I was going to make $75,000 a year. And I didn't work for that entire year. And so these are itemized damages. These are my special damages right here, $75,000, okay? And I would ordinarily need that before I even filed the complaint. in defamation per quote. In defamation per se, you assume that harm happened. Defamation per se is reserved for statements, false statements, that are just so bad that we assume that you suffer harm. And the categories of statements for defamation per se are really well established in Ohio and other states' laws. And it's really in three categories: that the person that you're yapping about committed a crime or specifically a felony, that they shouldn't be trusted in business. That's my favorite. That's like, who's going around saying Ben shouldn't be trusted in business? But if they do, that's defamation per se. And then you have like a very specific disease like leprosy. We did not include that in this case. But these are the categories of defamation per se. It's really important because defamation per se, again, you don't need this special damages requirement. It can just be kind of general. This person said this false thing about me, and it immediately harms my reputation because it's defamation per se. That's why it's important. Okay, against a public official, though, it gets a little more complicated. Like I mentioned, in defamation, a defendant must be at fault. Normally, that means that they're at least negligent, okay? So I don't want to dwell on this because, spoiler alert, this isn't the standard, but let me give you an example. A negligently false statement is like, I don't really know, I'm just going out on a limb, maybe I'm mistaken, I'm not acting careful, and I lie. Okay, that's negligence. But in a public official context, the plaintiff must prove actual malice, okay? And what that means is that the defendant knows that the statement is false, okay? Subjective awareness that the statement was false and said it anyway, or acted with a reckless disregard to the truth or falsity of the statement. So that's recklessness imputes a level of understanding, okay? I don't know exactly, but I've got a good idea that, you know, Ben didn't steal cookies from the cookie jar, but, you know, I did my research, I didn't see a story about it, trusted sources can't verify, but I'm gonna say it anyway, I think he stole a cookie from the cookie jar. Okay, that might be actual malice. The question obviously is, why are they different? Well, because we gotta be able to throw tomatoes at people in public office. We gotta be able to say things about these people who put themselves in the public light and ask us as the citizens to say, what do you think about this? What do you think about what I'm doing? I mean, you see this right now in all the commercials, right? Like, there's attack ads for a reason, okay? So that's why it's different. As long as the person who publishes the story or the statement about the public official doesn't act with actual malice, it could be false. It could be utterly false, okay? It could be defamation per se, doesn't matter. If they did not act with at least a reckless disregard as to the truth or falsity of the statement, it's not defamation. That is the actual malice standard, and that's what it means to be at fault. I already told you what the difference looks like. It's the difference between I know it or I research it and I don't, and I just kind of make a mistake. And I told you what the higher standard is. I'm well ahead of myself. Okay. This is a video I found, and I think it's fantastic. He does say damn at the end, but I think we can handle it.
The guy throws
He's talking about Tua.
Is there a video to show? Or?
There is a. Oh, I'm sorry. I did not show it.
No worries.
Interceptions tonight, including a pick six. And I bet you guys expected me to come out here and talk about how bad of a deal that is for the Miami Dolphins. You probably thought I'd say he's the Hawaiian Daniel Jones, and that we would have been better off lighting the $200 million on fire, but I'm not going to say any of that stuff because Tua just got his third concussion tonight. And I feel kind of bad. You know, I knew when DeMar hit him that one of those guys wasn't getting up. Now, for the rest of the season, the Miami Dolphins are stuck with one of the worst backup quarterbacks in the league. And there's not a damn thing I can do about it.
So that's That's a parody. I will, before we leave, I will draw your attention to the top line where it says parody 100% made with AI. I think that's fantastic. I'm glad that we're doing that now. And I saw that not 5 days ago when I was scrolling mindlessly on Instagram preparing for this presentation. So timely as ever, I guess. There is no, oh, thanks. There is no such disclaimer in Mr. Latu's video. I regret to inform all of you plaintiffs' lawyers out there. Perfect. Thank you very much. That's perfect. So that is like exactly what we're talking about. And that did not exist when we came up with this case. So again, timely as ever. So I also earlier, I loved the conversation about GPT. And I confess that part of this is AI generated. I asked GPT what is a parody, and it told me this, which is the art of taking something serious, slapping a mustache on it, making it do a chicken dance, remixing your favorite song, but replacing the lyrics with a love letter to pizza. Hilarious and totally legal most of the time. I think that's a great definition, but I said, try again, but make it funnier. And it said this: the delightful practice of taking a beloved work, turning it into a comedy skit and hoping nobody sues you, like dressing Shakespeare in sweatpants and making him rap about avocado toast. And I have no idea where the avocado toast came from, but I couldn't help it. I was like, if it's bad, I'll scrap it, you know? But these were both too good, so I included them. That's it. What I call it, imitating for the original for comedic effect. I think that's what it is. Importantly for you guys, parody is protected speech under the First Amendment. And that's important because, as I'll talk about later, we need to be able to make fun of people in these public positions because parody's really strong at doing that. Like the Miami Dolphins coach. I think of them differently, I think, after I saw that. So the other thing about parody, when you're deciding is it parody, is it not parody, parody more likely exists when it's not commercialized, okay? So like no one's making money unless that Instagram account takes off on that AI-generated deep fake of the Miami Dolphins coach. Very famous parody case that I will share with you is this fantastic Jack Daniels case, which you should not do outside research, but if you read one case, it's this one. These people started making dog toys that look just like the Jack Daniels bottle. And the one on the right's the dog toy. It's got a basset hound on it. And the one on the left is the Jack Daniels bottle. And they got sued like really hard by Jack Daniels. And they went up to the Supreme Court, and the Supreme Court said that is not a parody. That is trademark infringement. Because you commercialized it. You can't commercialize, you can't make money from parody. You can't make money from Jack Daniels' brand. You're infringing on their trademark. And the Basset Hound people were like, but it's really funny, right? And they're like, no, it's not funny. It's a tort, actually. So it's fantastic. That's parody. This is really important. The quality of parody, the taste of, like, how good's the joke? It doesn't matter. Are you offended by the joke? It doesn't matter. If it's parody, it's parody. And that's kind of what they tried to make the point in this Jack Daniels case. They were like, look, they're only mad because it's really successful. And like that's not good enough. It's got to actually have social commentary to it. If it doesn't have social commentary, it's not parody. You're just ripping off somebody else. So to determine whether it has social commentary or if it's parody, a lot of courts will use this reasonable reader test. You might think of this in your case as a reasonable observer, a reasonable video watcher test. The question is whether that reasonable person would understand that the parody is parody. Obviously, to a video, it says it's a parody, okay? That's a strong indication that it is a parody when you admit it. But when they don't, like in this case, it gets a little more difficult. So who is the reasonable reader? I love this quote. He is no dullard. That is out of a Supreme Court case. He is no dullard, and so he's not a dunce. He has his wherewithal about him, and he can look at it and go, I think that's kind of funny, or I don't think it's kind of funny. I think it's real or not. Courts say it is not some totally humorless drudge who cannot perceive the presence of subtle invective, which again is just a fantastic quote. That drives it home. I get a kick out of reading parody cases because the courts write them fantastically. And I hope you get to see that in your cases. So this is, again, it's not somebody who's going about life thinking everything's literal and that nothing is funny. but it's not a person who doesn't take stuff seriously. It's kind of your middle of the road. One of my favorite examples of the reasonable person from law school is it's the man who rolls up his sleeves, mows the grass, and reads magazines. That's actually from a court case. So just think of like your average dude or gal. That's your reasonable person. And finally, critical to the TUA example, you don't need a disclaimer. A parody can be a parody without a disclaimer. Like when we watch Saturday Night Live, a lot of that stuff is parody. You kind of know because it's Saturday Night Live, but if you just turned it on, you would not think that those people were actually those people saying those things. You kind of know. So you don't need a disclaimer. Okay, now we're getting to why you should care about all this stuff in parody. And this, I block quoted this because it's fantastic. The last thing we need, the last thing the First Amendment will tolerate is a law that lets public figures keep people from mocking them. And that is exactly what you're dealing with. It's like sums it up perfectly. I will ask you to consider the following. Does Latu contest defamation? I don't know. Maybe Latu does, maybe Latu doesn't. Can Saidi's harm be compensated with money? Maybe, maybe not. I would ask your defense lawyers to consider it if they think he can, or if they think he can't. Is Saidi a public official? Probably so. I'm going to kind of rip the rug out from this one. He probably is. I mean, he's running for public office. He's the principal of a public high school. He's probably put himself out there already. But look, I'm not saying that I wouldn't be shocked if someone said maybe he's not. Latu says, I'm just making fun of Saidi. When you read what Latu had Saidi say, maybe he is, maybe he's not. It's a really nice typed out paragraph long script of what was said and what happened, and it is for your indulgence and enjoyment. Like was mentioned, it does involve drunk driving. I wore my mint julep tie to celebrate the occasion, actually. And so I'm looking forward to everything that your students will do with this fantastic script that if your principals have a sense of humor, then they should love it too. But it's pretty good. I think it's pretty good. Remember that at the end of the day, Saidi does bear the responsibility for proving this case. Okay, so there is no burden on the defense. I will out and say that. I hedged earlier at lunch when I was talking with another coach on whether the defense has a burden. Look, if you walk in as a defense in a preliminary injunction case, a lot of these times, I mean, the burden is really high. The plaintiff has a pretty strong case walking in. It's not a bad case off the rip. You've normally got to put something up to rebut some of these factors. In this case, obviously, you're working with the reasonable reader test. And so my personal take on, the standard and the factors and the burden of proof is that it is true that the defense has no burden, but I would expect the defense to get up there and say, hey, this is what happened, not necessarily getting out over their skis and saying, we're going to prove to you beyond a reasonable doubt, blah, blah, blah. But get up there, tell a story. The defense has some work to do in this case, I think. But it is absolutely appropriate for the defense to say, this is Saidi's burden and his burden alone. And so hold Saidi to that standard. When you're doing this, consider obviously for the plaintiff the likelihood of success on the merits. Remember, Saidi needs to prove defamation. That's what Saidi needs to prove in this case. Saidi's irreparable harm. Identify what Saidi suffered or what Saidi will suffer. Think about who the balance of harm favors. Obviously, for plaintiff, you're going to say that the plaintiff is favored in the balance. Defense will say defense. But think about how to rhetorically twist the facts in an ethical and civil way to favor your side of that. And finally, whether the injunction serves the public interest. Is it really what we want to quell the voices of the student population who are just trying to do something to get their voices heard? Or, should we have fair and free elections that aren't inundated by AI skits of people saying things they never said? I don't know. I think it's a really, really cool topic for run up to an election year in that context. So I'm excited to see what the students will say. For the defendant, think about, there's nothing to shake a stick at here with Latu's First Amendment rights. I mean, Latu has significant First Amendment rights to say what Latu wants to say about a person who's running for public office. And remember that parody is super strong medicine in public discourse. Of course, Saidi will say, well, it's not really a parody, it's a poorly thought out, thoughtless prank that this kid's pulling against me. But if it's a parody, that's a stronger case for the defense. Think about the reasonable viewer, think about the reasonable reader test, and present those facts accordingly. Much like last year, I left plenty of time for questions. Happy to take them. We're really excited about this case. I have an image of the video in my mind. I hope you will too after it's done, but we hope you enjoy. Are there any questions? Much like last year, it only takes the first one, and then you guys will start to rip, and that's totally fine, but who's going to be the first one? Anything. Okay, there we go.
I would think the difficulty would be in proving that just because he is a candidate for public office and that he is a principal at a public high school, that he is therefore a public official.
Sure. There could be difficulties in that. I think we might have written it out, if I'm being honest. I think it's like he's a public official. Just from behind the curtains, I mean, case balance, you want the actual malice standard. Also makes a better case for the kids to argue about actual malice. So my inclination is that, again, unless it's written out, I can't remember right now, I wouldn't, dismiss offhand an argument that he's not a public official. I'd wonder how far it gets you in this setup where the court's already said, okay, give us evidence, put it on. Obviously it helps your burden, but where we're at, I don't know how many mock trial points it gets you, I guess I would say.
I will say we didn't stipulate necessarily that they were a public official, but there is nothing in the case law that would support a finding that they are not a public official. So if your students are making that argument, like they can use the factors that are there, but it's going to be really difficult when the case law supports a candidate for office, for public office, being a public official.
Yeah.
Right. So it's not their role as principal, it's their role as a candidate for office.
And I mean, I do remember the law on that is like once you kind of put yourself out there, like there's a concept called limited public officials. Like I might be a limited public official with respect to like this presentation because I've stood up in front of all of you and I can take your critique. And so I do remember that there's law that once you kind of say, hey, comment on me, that's where it's at. And I will say, actually, I forgot to mention this in the slideshow because I remember during your rule presentation, this new evidentiary rule about hearsay and reputation in the community was added to affect the defamation claim. In defamation, his reputation, Saidi's reputation is at issue, and because he's a plaintiff and he filed, he put it at issue. And so when people are commenting about, I don't like him as a candidate, he's not a good candidate, okay? Ordinarily, that might be subject to hearsay issues, character evidence issues. Because it's defamation, we're trying to give you guys the runway to make those arguments and to convince your judges to let you make the arguments. So that's another peek behind the curtain that I thought deserved some airtime. Anything else about this case or the First Amendment or parody? I'll make fun of myself, that's fine. I also asked ChatGPT how I should do this to make it funny, and it suggested I wear a clown wig with a judge's robe. So I didn't do it. I know.
Is there anything to do with like the school environment related to this defamation or anything like that? Is the defendant a student, right?
Defendant is a student. There's no Tinker, no Hazelwood, nothing like that.
Okay.
Anything else? Get your steps into it, right?
Pacing back and forth.
Just for clarity, you were talking about parody as a it should have more social commentary rather than for financial gain. But a parody could still have a financial gain aspect to it, right? It's supposed to, am I supposed to be thinking of this as a scale? It's more social commentary than financial gain. As long as it's that way in the scale, it counts as parody. If it's more for making money than social comedy, then we're on the other side.
Yeah, you're thinking about it the right way. It's kind of, I guess we would say, a sliding scale. More money is less parody, less money is more parody. But yeah, I mean, you'll see it in there. That's a good little tidbit for the students to help understand it, I would say. I don't know that there's anything in the case. Actually, I would say there's nothing in the case that suggests.
Yeah, there's no pecuniary value to the video. So
there's nothing in there like that. But it gave me an excuse to talk about the Jack Daniels case, and so I had to do it. Anybody else? All the way.
Related to the hearsay objection, can you give an example of that? Is that more like somebody saying about somebody's reputation?
Yeah. So the hearsay exception in the federal rules, it's 803.23, I think, and it essentially says that statements concerning a person's character or reputation within the community is accepted from the rule against hearsay, and it's the most backwards hearsay exception in my opinion, because it's like a person could sit on the stand and be like, yeah, I live here and I talk to people about Ben, and yeah, everyone's saying Ben's horrible, he's a bad guy, and that's just like rumors, right? And so it's normally what hearsay is not allowed to do. But one of the only ways that we found to prove someone's just general reputation is just to source the community that they live in. And so kind of as a necessity of that's how we prove it, there's this hearsay exception. And so it would come up like that. If someone says, I go to Rossi's and the talk of the town is Denver Saidi's a great guy. Okay. Well, that's going to be accepted, or should be accepted probably under that exception.
A gloss that I would add on that too, though, I think that our students struggle a lot. Everyone struggles a lot with hearsay, with that truth of the matter asserted part. Mm-hmm. There are elements in this case where it's not actually being offered for the truth of the matter asserted. So it's simply that people said it, not that what people said was true. And that's a distinction I think our students miss a lot. There are instances where you're going to want the reputation to come in, and that's why that's there for you as a shield. But a lot of the ways your students are going to want to use some of those community rumors are not actually being offered for the truth of the matter asserted. And I think it's a good way to teach our students what hearsay actually is, when you start kind of piecing through, okay, do we need those rumors to be true, or do we just care that they are rumors out there being said? That's the distinction.
I completely agree with that point. We talked a long time about whether to include, because and Ryan's right, a lot of the scuttlebutt around town is probably not offered for the truth. And so we talked about whether to even include the rule, but at the end of the day we did, just for an extra comfort. But he's right, a lot of this is probably not for the truth. Anybody else?
Yes, so it is Denver Saidi v. Wyatt Latu. We'll just stand here awkwardly and uncomfortably waiting.
Yes, sir. Okay.
I may have missed it, but is there any specific legal wrench or challenge because the kid made it with AI as opposed to making it himself? How much does that fact weigh into this case, or is it just like a modern touch to make it seem more real, I guess?
Yeah. My knee jerk is to say it's a modern touch. But you'll see, he posted it. I do keep using he, him pronouns, but it's obviously you can make them any gender you want. Latu posted to the very well-known video sharing site Tactic, and it circulated quickly. And so that is how he's publishing this statement on Tactic.
In terms of, is there a legal test for that? There isn't yet a legal test that we were able to come across in the case law, because it is so new, but give it time. because, you know, even in the current election cycle, like literally as we were editing the case, news stories were coming through about, you know, false videos, deepfake videos being published, questionable, you know, sourcing of material. So there will eventually be some element added, but this really is a case of first impression, not just for the fictional world of Buckeye, but in the real world as well. So. I'm
waiting for a politician to get up and say, oh, that horrible fact about me is a deep fake. That video from 20 years ago where I said that's a deep fake. Don't worry about that. I mean, like, I think we're close. I really do. It's kind of scary, but that's where we are. So we wanted to do an AI thing, and this we thought fit well because with the principal and everything. But that's my answer.
Well, there was kids were making fake videos about principals and teachers.
Kids were making fake videos about principals and teachers. Yeah, I believe that. I totally buy that. Yeah, I'm just waiting for it to hit like CNN or Fox. That's all I'm saying.
I just have to ask, when was the video shot, and did Danielle know when she was mentioning cats and stuff that was going to be in the most recent debate?
Oh, I don't know.
The video was filmed a week and a half ago. Make of that what you will. It's up to
you. See, this is the energy we want for a parody case. That's right.
Other questions?
Anything else?
Is there an actual video?
Is there a video of the video? Unfortunately not. No. I know.
And to be honest, the reason is for the exact reason you'd imagine. The individual is a witness in the case. So we don't know their gender, appearance, anything. So we can't create a video of a person who is going to testify or could testify in. Correct.
Is the text of the video in the
Yes, the full transcript is one of the exhibits.
There's a full, so the exhibit is a transcript of what was actually said. It's at an event. It is at a school event, but it's not a school issue. It's the text of what was said at the event by the principal, and then it's the text of the video, as it's called. And you'll see it's, I don't know, is it too on the nose, too close, too far? I don't know. That's the whole fun of it, absolutely.
Anything else?
So I don't even know if this is really a question, but I guess I'm interested in the case law and seeing how recent some of it is, because when we're thinking about these parodies, right, like we're at a far cry now from like a cartoon comic that used to be put in the newspaper that's a parody to now it literally looks like you, and I can't even tell that that's not the coach talking, you know, and this is like a huge leap from when I think, you know, the founding fathers first thought of parodies written in the newspaper, right? So has there been, like, is the case law, I guess, is there some recent case law in there with some more digital age rulings, or I don't know.
Well, I would start by saying that foundational defamation law dates back to the 50s, I think, was that Sullivan in the 50s. And I mean, that's bedrock, you know, defamation case law. The next big parody case law was Hustler, and I think it's the 70s. And, you know, obviously salacious details ensue in Sullivan. And so when you have Sullivan, it's a highly redacted version of Sullivan, but it's a fantastic case, obviously. And so those are in there. I mean, we did attempt to find what we could, but I mean, Ryan is absolutely right. Like, there's not, I think I did Alexa search myself, and there's just not like AI deep fake defamation on Lexis. Right.
And I think, I mean, a lot of the reason too is that the test still stands, right? So, I mean, even though the case law is written at a time when you're looking at a comic, right, or you're looking at a statement in a newspaper, the test still stands. Mm-hmm. So it's considering whether or not the reasonable viewer who lives in the modern age and knows what deepfake is would see this and know it is or isn't real, is or is not funny, right? Because so I think that because the test itself hasn't really evolved much, there's not really a need for updated case law, But I think we're going to start seeing more examples in the case law of instances where the court found that it was or wasn't parody, was or wasn't defamation. Right? It will eventually get there, but I don't think they'll apply a different test in the Flint case. That's probably still going to be.
Does the reasonable reviewer actually know it's a parody?
Well, and
The actual person, are students being told it's actually their image as opposed to someone like Saturday Night Live playing?
Yes.
Correct.
Yeah, so the question is, are students being told that it's their image, and it's, in this case, Saidi's image? And yes, I mean, it is, let me be careful about it. It is Saidi's image with care taken to explain how one viewing it might think, is that real? So like when you watch AI, the coach one was a bad example because unfortunately that's just a really good deepfake. But like when you watch, especially early generative AI for videos, like the hair looks weird or fingers look weird or like they can't eat spaghetti or like whatever. So we tried to incorporate these physical indicators in there, but I think Saidi's affidavit says when he saw the video, it's me. And so I mean, it was Saidi.
Anything else?
Okay. 13 minutes early. Okay, well, thank you for listening. I really hope you enjoy this case. We worked really hard on it, and we're really excited to see what your students do. Thank you.
Thank you, Ben.